Today we are discussing the Good Cause Eviction Law that was passed just over 1 year ago, becoming effective on April 20th, 2024. What have we learned from the courts or otherwise in the first year of this historic statute? Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments: rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. I am Michelle Itkowitz, and today we're discussing the Good Cause Eviction Law that was passed just over 1 year ago, becoming effective on April 20th, 2024. What have we learned from the courts or otherwise in the first year of this historic statute? As always, first we're going to set the stage with some context. In New York City, we have 5 categories of rental housing. There are more than 5, but there's 5 big cohorts. Let's start with free market apartments. That's the one that's most familiar to most people. In a free market apartment, the landlord is able to offer to rent the apartment or, upon renewal, to offer a renewal of the lease at any level. That doesn't mean you have to agree to a rent increase on renewal. You can always reject the rent increase that the landlord is proposing and choose to move out. Or if you reject the increase and you and the landlord can't come to an agreement, you don't move out, the landlord has the option of evicting you on a holdover. There are no restrictions on how much rent the landlord can insist on. But that doesn't mean that free market tenants don't have some protections in place that would slow down an eviction, but a free market tenant's protections are nothing even close to what a rent-stabilized tenant has. So let's do that next. Number 2, rent stabilization. In New York State, we have had a statutory system in place since the early 1970s called the Rent Stabilization Law, which applies to about 1 million apartments in New York City. If you're rent stabilized, that means that your rent can only go up by small increments governed by certain guidelines, and your landlord must renew your lease. You can't be evicted except for good cause. And rent-stabilized tenants have extra methods for enforcing their housing rights in addition to the court system. Tenants can go to the New York State Division of Housing and Community Renewal, the DHCR. It has an adjudicative arm where rent-stabilized tenants can go to enforce their rights without a lawyer and cheaply. There are other benefits also to being rent-stabilized. It's good to be rent-stabilized. Number 3, there are co-op apartments. Certain buildings are owned by special cooperative housing corporations. And when you buy a co-op apartment, you're really buying shares of stock in the housing corporation. And then the housing corporation issues you a long-term proprietary lease for your apartment. Co-op purchases can be financed by a bank. Co-op shareholders pay rent, which is referred to as maintenance. Co-ops look and feel a bit like home ownership, but they really are long-term leases. There are 380,000 co-op apartments in New York City, and I'm getting these numbers, by the way, from the New York City Rent Guidelines Board Housing Survey, which gets its numbers from the U.S. Census. Number 4, we have affordable housing. And in this category is any type of housing that's dependent upon your income and your assets. The aforementioned rent stabilization is not dependent on your wealth. You could be a millionaire and live in a rent-stabilized unit. In affordable housing, I include the New York City Housing Authority apartments and HDFCs, Housing Development Fund Corporations. Those are buildings that are privately owned, but the mortgage is subsidized by the federal government, and in exchange, the rents have to be kept down to a certain level, and the tenants that are allowed to live there have to be certified as eligible based on their income and assets. There are approximately 168,000 of these types of apartments. As of a year ago, we have a fifth major category of housing unit because on April 19th, 2024, the Good Cause Eviction Law was passed, and it's historic, and it's the biggest change we've seen in housing in 50 years. We covered the Good Cause Eviction Law so far in 4 episodes. Episode 25, we covered what protections exactly the Good Cause Eviction Law provides. In episode 26, we covered which apartments are covered by the Good Cause Eviction Law. In episode 27, we covered Good Cause Eviction Law notice requirements, which ironically apply now to all apartments. In episode 29, we had a veteran landlord lawyer come on and a veteran tenant lawyer, and we had a panel to discuss the important questions raised by the Good Cause Eviction Law. Obviously, I'm not going to repeat all that here. Long story short, for purposes of this episode, the Good Cause Eviction Law puts some limits on rent increases and only allows landlord to refuse to renew or to evict for good cause shown. The Good Cause Eviction Law protections overall are not as strong and as good as those protections that rent-stabilized tenants have. But Good Cause Eviction Law is better for tenants, way better than being free market. The Good Cause Eviction Law pulls from the free market cohort we just discussed. In other words, the Good Cause Eviction Law apartments never come out of the affordable housing apartments. It's never coming out of the rent-stabilized apartments. It's never coming out of the co-op apartments. Before April 19th, 2024, in the Good Cause Eviction Law passage, there were 1.1 million free market apartments. Now, this next sentence that's going to come out of my mouth, I don't really have any data for. This is a guess based on me knowing what type of apartments the Good Cause Eviction Law applies to and looking up how many of what type of buildings there are. But I really don't have actual data for this. I am guessing, therefore, that probably half of the 1.1 million free market apartments were converted into Good Cause Eviction Law apartments. If you have an exact number, shoot me an email. So now the Good Cause Eviction Law is over a year old. There are about 14 published cases on the Good Cause Eviction Law on Westlaw, and a dozen of those are really about whether the law applied to cases that were in some stage of being initiated or had just started in and around April 2024. You always get that at the beginning of a new law, people arguing whether the law applies to existing cases. But honestly, none of the published case law at this point is all that interesting. I choose cases and statutes and situations to share here if I think they will lead to some useful tenant takeaway. Can we learn anything from the things we're looking at? And I honestly don't think any of these 14 cases so far are that earth-shattering or really have any teachable moments in them. But I did recently have a case of my own that resolved outside of court that is worthy of sharing with this audience. Thus, I offer you a Good Cause Eviction Law anecdote of a real case where I represented a real tenant. Here is my Good Cause Eviction Law anecdote of a real case where I represented a tenant. In January of 2024, 90 days before the tenant's lease was to expire on April 30th, 2024, the landlord offered what was then a free market tenant a lease renewal that would take the rent from $5,000 to $5,500. But on April 20th, 2024, the Good Cause Eviction Law was passed and applied to this particular apartment. If you want to remind yourself which apartments the Good Cause Eviction Law applies to, then you can go back to episode 26. The tenant didn't sign the 2024 renewal offer until April 24th, and the tenant didn't get a fully executed copy of the 2024 renewal back from the landlord until April 30th, and obviously the new lease didn't start until May 1st, 2024. And there's no doubt that the lease renewal should have been governed by the Good Cause Eviction Law, which kicked in on April 20th, 2024. The Good Cause Eviction Law would have limited the increase to 8.82%. In other words, the tenant's rent should have been $5,441, 5441, and not $5,500. That's a $59 a month difference in landlord's favor. But the tenant didn't realize that the Good Cause Eviction Law had passed and didn't know anything about it, and therefore he accepted the renewal and paid the rent for a year. In January 2025, the landlord, who was by then complying with the Good Cause Eviction Law, attempted to raise the $5,500 rent by the Good Cause Eviction Law limit of 8.82% to $5,985, $5,985. The tenant emailed me and I pointed out what had gone wrong. This was probably something the tenant could have handled on his own, but he asked me to handle it for him, so I wrote a letter to the managing agent. I pointed out that the landlord owed the tenant $708 from last year's $59 per month overcharge, and I'd like to see that as a credit against the May rent. And I also pointed out that the new rent should not be calculated based on the old illegal rent of $5,500, but should be calculated based on the rent that the tenant should have been charged on the 2024 renewal. Remember, that was $5,441. So instead, the new rent shouldn't be $5,985. The new rent should be $5,920. Now, as you can see, under the 2024 renewal, the tenant was overpaying by $59 a month. But for the 2025 renewal, had the adjustment not been made, the tenant would have been paying $65 per month too much. And that's because the very important point here is that with any rent regulatory system, whether it's rent stabilization or the Good Cause Eviction Law, the rent compounds. In other words, the new rent is calculated based on the old rent. And if the old rent is too high, the new rent is even more inappropriately high. To the managing agent's credit, they got back to me within 24 hours. They apologized for the mistake and they offered the $708 credit for the May 2025 rent, and they issued a new lease renewal offer with the lower rent. All of this brings up some very important tenant takeaways. First, let me get the housekeeping out of the way. This is not legal advice. I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it is terrible, because I'm asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about. Please subscribe and give us the highest rating. It's time for the tenant takeaway. Tenant takeaway time. The landlord in my anecdote was a big managing agent, and the building had 423 units in it. Rental season is really spring and summer, but just for the sake of keeping the math simple, let's say 1/12 of the building had leases that expired on April 30th, 2024, like my client did. That's 35 units. 1/12 of 423 is 35. If on that renewal, the landlord was going to make an extra $708 on my client, multiply that by 35 units, and that would have been $24,780. Let's just round it up to $25,000. So by that one little error, that's $25,000 that would be in the landlord's pocket and not in the pockets of the tenants that the Good Cause Eviction Law was meant to protect. But now let's consider that other lease offers were sent to tenants 90 days ahead of their expiration, such as the people whose leases were going to expire on May 31st, 2024, and those that were going to expire on June 30th, 2024. They also probably got their lease renewal offers before April 20th, 2024, when the good cause eviction law went through. So those tenants could have been in the same situation as my client. And if they didn't hear about the good cause eviction law, if they didn't understand that the good cause eviction law applied to their apartments, and if they didn't understand how the good cause eviction law worked, and they renewed their leases for the spring, summer of 2024, they could be in the same position as my client. So that gets us to a place where maybe the landlord made $75,000 on the uncorrected mistakes for a quarter of the building. And that's in 1 year. Maybe this very large, very professional managing agent made a legitimate mistake, but I'm just saying it's a whole lot of incentive for landlords to have made those mistakes in the spring of 2024. Now, spread that across all of the housing in New York City, and that's a lot of potential for mistakes. Again, then consider this fact. It's even more important. The effect of the mistake compounds. In May 2024, my client was paying $59 a month too much. But if I hadn't stepped in, or if somebody hadn't stepped in, the client could have handled this himself, and pointed out that there was an error. Then by May 2025, my client would have been paying $65 a month too much, and it just would keep going up year after year. In episode 29, those two other lawyers and I talked about the challenges that people subject to the good cause eviction law might face. And one was the fact that a good cause eviction law tenant who is aggrieved by an overcharge doesn't have the low-cost DHCR proceeding option that rent-stabilized tenants do when they have an overcharge complaint. And an overcharged good cause eviction law tenant really only has the option to not pay the rent and hope to not get sued. And if you do get sued, then to raise the good cause eviction law as a defense. You could probably bring a declaratory judgment in Supreme Court, but Supreme Court is very expensive to litigate in. It's very difficult to navigate without a lawyer, and cases in Supreme take years to resolve. So the takeaway is, if you're in a good cause eviction law protected apartment, and again, you can check our coverage episode 26, to see if it applies to you. If you're in a good cause eviction law protected apartment and you got your lease renewal offer before April 20th, 2024, and that offer was for a lease that was going to start after April 20th, 2024, your rent increase should have been based on the good cause eviction law current 8.82 limit. Unless your landlord was attempting to raise it more than that based on some type of good cause shown, which is part of the law we talked about in episode 25. But if the landlord didn't disclose anything, if they didn't have a reason, if they were silent on it, the increase should not have been more than 8.82%. And the longer you let that incorrectness stay in place, the more rent you're going to overpay over time as that discrepancy widens, because again, the future rent is always calculated based on a percentage increase on the current rent. So if you're subject to the good cause eviction law and you renewed your lease last spring, double check those numbers. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Idkowitz, and this is the Tenant Law Podcast.